right, we will hear from the appellant.
Good afternoon, Your Honors.
Good afternoon.
This matter, Your Honor, comes down to
Do you wish to reserve any rebuttal time?
2 minutes, Your Honor.
2?
2 minutes.
Okay.
This
All right,
matter
sir.
comes
You need to
down
introduce yourself first.
I'm sorry, Your Honor. James King, Your Honor, here on behalf of Pamela Crenshaw in this matter.
All right, sir. You may proceed.
Thank you, Your Honor. My apologies. Your Honor, this matter comes down to the HIPAA authorization that was forwarded to defendants on about March 29, 2023. Upon filing suit, we received a motion to dismiss. The basis of the motion to dismiss was that the HIPAA authorization did not allow the parties to receive and or disclose records, and therefore they were prejudiced, allegedly, is the argument. Our HIPAA authorization, Your Honor, contains all the core elements that is required under the law to allow a defendant to receive and or disclose records. The issue, I think, the more salient issue with the HIPAA authorization is that the defendants argued in the trial court is that because each one of the providers in each section of the HIPAA authorization and the part that allows them to receive the records and the part to disclose the records had a single dash by each provider. Allegedly, the dash by the providers, according to the defendants, and the trial court ruled in this way, would not allow them to receive the records.
Counsel, what is the purpose then of the dash? If it's not potentially you could mark this party, this entity, this individual, what's the purpose of the dash? Your
Honor, the purpose of the dash was frankly to, my paralegal did this, but it was frankly to enumerate the list of different providers that were there. Now, could you have actually put an X?
A question with that. If it's not a mark the blank, I mean, maybe it's not a mark the blank thing. What do we make of part 2 of the document where there's an X next to entire record?
Okay.
And so it's not the whole form that's not marked. It's entire record has a mark next to it. So how do we reconcile it's not a place to mark when something's marked in part 2?
Okay, so with regard to the part marked in part 2, if you look at the core elements, you have to let them know basically what records they can receive. So to be frank, we were just making sure that they could receive the entire record. If you chose to receive the record, you could receive the entire record, and we were making that just clear. But with respect to the authorization form, the individual or organization is authorized to make disclosures. We list each and every party in here that's allowed to receive and or disclose the records.
But Counsel, that seems to create an inconsistency between how you're treating those dashes, those blanks, whatever we're going to call them there, in part 1 and part 2. In part 2, you're saying that it is something to be marked, and in part 1, it's not something to be marked. And
yeah, it could. The way I reconcile this is that if you chose to mark one, you could, but if you didn't, you didn't have to. The point is that.
But wouldn't that be the provider then providing the authorization? So I mean, if I receive this and I'm one of the physicians that's named here, and I don't know how I would know that I could mark this. I mean, is this really is this really Ms. Murphy, the authorization coming from the patient, or am I then the one authorizing it if I'm the one that marks it?
Well, when an authorization is forwarded, there's a letter that an attorney will send enclosed piece finding authorization to disclose records on behalf of Ms. Murphy. Please provide the entire record and provide them to our office on or about this particular date. That's typically what happens when a party requests records. And that's all that would have had to been done here, is to request the records. Now, if one of the parties had decided to place an X there, there's nothing in here, Your Honor, that the plaintiff intended to, and the lower court ruled this or found this way, it was something that would have put them in some sort of jeopardy with respect to the HIPAA requirements or the core requirements in order to send out the records. There was nothing in hitting or putting an X there that would have caused any type of issue with regard to anybody who was trying to send or receive the records, or who was trying to receive and or disclose the records. So the form lays out every party that could get the records, with the exception of one, which is another issue with the authorization, and rightfully so. That issue is it left out Memphis Healthcare, Memphis hospitals. However, Labana Healthcare was named in the lawsuit. The two entities are represented by the same counsel. Had Labana intended to utilize the records to receive records? In fact, Labana is the entity that you receive records from when you ask for records from Methodist South.
In your complaint, you associated, you had a DBA listing here, right? That this is doing business as in your complaint.
I think it was also known as.
So I think you have an allegation of that in your complaint, if I remember correctly. Would that?
DBA, doing business as Methodist Labana Hospital South.
Is that enough to take care? Do we need to even worry about, and for purpose of motion to dismiss, don't we assume that that's true, that it's doing business as?
Correct.
So do we need to get into whether they're the same board or not the same board, or?
Well, yeah, and because Methodist South was actually listed on the HIPAA authorization form, they were. So if Your Honor's, in answer to Your Honor's question, that is correct, that since Methodist Labana was literally listed as a DBA on the form, then the HIPAA authorization that allowed them to receive records, they were clearly on there. So that would foreclose that. But the trial court, although the trial court made reference to it in the record, the trial court didn't really get much into that. Now, with respect to the statute of limitations, we filed in our reply brief a case style Vilas versus Love. Now, I think that case is on point for several reasons, because in this particular matter, Your Honors, in the Vilas case, there was an argument or an assertion that the college student in that particular case should have become aware of the cause of action because he had a meeting with the doctor on some particular date, and then thereafter having a meeting with the doctor, that the doctor gave him a form and instructed that indicated that there could be a possibility with an appendix not being appropriately removed from the plaintiff in the Vilas case. The Court of Appeals, I think it was this court, held that a plaintiff is not sophisticated. They don't understand medical jargon. They don't understand issues such as that. And so just because you give a plaintiff, have a meeting with the plaintiff, or suggest that you told them that something may have been wrong with them in a form, in a medical form, lay people like Ms. Crenshaw, who is a waitress, does not have the sophistication to understand or appreciate that she would have had a cause of action on March the 25th when her mother entered the hospital, on March the 26th, on March the 22nd, on March the 28th. And so the basis of that case simply stands for the proposition that there's no way she could have discovered it on that day, and that our filing the pre-suit notice or sending the pre-suit notice out on March the 29th, 2023 would have been well within the statute of limitations, because my client would not have been, as a layperson, would not have known that she would have had a cause of action, or there had been an injury to Ms. Murphy on the date that she entered the hospital or any of the dates that she had communications with the doctors while she was at the hospital, as we alleged in our.
So, Mr. King, according to your argument, when do you allege that the cause of action actually accrued?
Okay, so what we did in the complaint and what I argued in the brief is that if we look at for the purpose of Rule 12, under Rule 12, you have to take all reasonable inferences, and so the Miss Murphy passed away on April the 2nd of 2023. The complaint was filed on April the 9th. So what we're alleging, or what the reasonable inference from the complaint should be, is that she would have known or sometime around that time when she passed away. And that's the position that we took in the brief. So if the court finds that the HIPAA authorization is compliant, then the 120 days period that's found in the statute would provide enough, would have made the filing of the complaint timely in this matter. So therefore, the plaintiff or the appellant in this matter takes a position that the lower court was wrong in holding that the defendants in this matter, if they place an X by the name of one of the providers on a HIPAA authorization, would be somehow in violation of the HIPAA laws. I take an issue with that. I say to the court this, that if we're providing a HIPAA authorization and providing an authorization to a party, and you tell them this is the authorization to use, there are no dashes or no parts that are missing any data or anything like that, why then would we ask them to use the HIPAA authorization, and then who would we be, how would they then therefore be somehow in some sort of, have some sort of issue with federal authorities if they provide a HIPAA authorization that the plaintiff has told them to utilize with respect to receiving or disclosing medical records? I find...
Mr. King, let me ask you a question along those lines. If some of the defendants marked an X, as you stated, onto this form, would they not be altering a form that had been signed for HIPAA purposes by your client? Would that not be altering that form, and then would that not be a problem?
Well, Your Honor, yes, they would be altering the form, but from the plaintiff, from the perspective of the plaintiff, it would not be a problem because, again, you could have sent the form without an X on it at all. However, if they did, there would have been no ramifications with respect to that because there was no issue with the plaintiff, because if the plaintiff put the X there, assuming that they may put an X there or a check mark there or not, it's the position that we're taking is that that X there does not render the HIPAA compliant authorization non-compliant. I think it substantially complies. In fact, I think it complies. I think it complies. So it would necessarily be a harsh result to say that by placing an X, or they may place an X or may not place an X on the form, that there was somehow some issue that would that would be an some sort of deal with the form, that there would be an unauthorized change in the form that's not that violates the HIPAA requirements.
Thank you, sir.
Good afternoon, Your Honors. May it please the court. My name is Will Podesta, and along with Claire Sissel, I represent the appellee defendant, Dr. Ravi Madasu. I'm going to be speaking to the global issues in the case that apply to all of the defendants, including the co-defendant physician, Dr. Motley, who's represented by Maggie Roney and Noor Obaji. And it's my intent to reserve about 4 minutes for counsel for the Methodist defendants, Jill Steinberg, to address the issues that only apply to those Methodist defendants.
So you want to take 11 minutes?
Yes, Your Honor, if we could do that. Thank you.
All right, you may proceed.
This court should affirm the trial court's dismissal of this healthcare liability action on 3 independent grounds. First, this action is time-barred because plaintiff did not send any pre-suit notice within the 1-year statute of limitations period. Second, the pre-suit notice itself failed to substantially comply with the statutory requirements. And third, because that pre-suit notice failed to substantially comply, plaintiff was not afforded a 120-day extension to the statute of limitations, rendering the complaint time-barred on that independent basis. Irrespective of whether the HIPAA authorization and notice letter themselves were compliant, the action is time-barred because no pre-suit notice at all was sent within the 1-year limitations period. This is a healthcare liability action that centers on a claim that the defendants delayed in diagnosing and in treating an infection. The decedent presented to the hospital, the ER, and then was admitted on March the 25th, 2022, which is the date of treatment at issue. It was not until the 3rd day of that admission, on March the 27th, that the decedent was administered any antibiotics. It was on the following day, March the 28th, according to the complaint, the plaintiff, who is the decedent's daughter, spoke with decedent's treating physicians about the decedent's medical condition. And so on March the 28th, 2022, the plaintiff knew or should have known all of the facts that constitute her claim of this delay in treatment, which was that the treatment was delayed until the 3rd day of this admission.
Was the daughter informed on the 28th of the determination of sepsis? Does the complaint indicate whether that information was provided on the 28th?
No, Your Honor, the complaint does not spell that out. The complaint does indicate that the plaintiff spoke with the treating providers, and I think it's important to recognize that it's not only the plaintiff's knowledge that is pertinent here, but also the knowledge that the plaintiff should have had through doing reasonable investigation and the like. And
What's the information that on the 27th or 28th, and opposing counsel suggests instead April 2nd, if I'm remembering correctly, sort of as the key triggering date, what's the information on the 27th or 28th that would have created sort of a reasonable expectation that she was on notice that she needed to investigate further?
Yes, sir. That information is that it was not until the 3rd day of her mother's hospitalization that anyone treated her for this infection. And the law is clear that a claim is not told until the full extent of damages are done, and so the claim is not told until her death on April the 2nd.
What would have told her that there was some sort of medical negligence that was involved in terms of if the doctor comes in and says, we've started treating for an infection, what would have told her that there was medical negligence that was afoot?
Yes, Your Honor. I think the pertinent question is not whether the plaintiff knew that those facts constituted medical negligence, because the statute is not told until the plaintiff learns that there was a deviation from the standard of care. I think
what should have launched the investigation, though? I mean, it's what there is enough of a trigger that something might be amiss here that I should be looking further into this. I mean, what key facts in the complaint are being related to her that would communicate that maybe there's a problem? I mean, not enough to, she's not a lawyer, she's not a doctor, but I mean, what would have triggered her investigating rather than just, beloved individual in the hospital and is sick and the doctors are taking care of the individual?
Sure. I think first and most prominently is that there was that 3-day delay in treatment. And
What does that mean, in treatment? She's in the hospital.
Right.
There are doctors, and I assume personnel going back and forth. But what is it that she knew? I'm having the same problem that Judge Usman is having here, is what what occurred that made this person aware that, hey, we got a problem here?
Yes, sir. And I guess another pertinent fact that is set forth in the complaint is that this infection was present when the decedent went to the hospital on the 25th. And so,
Did the daughter know that, though? I mean, did the daughter know that she had an infection on the 25th? So when she's talking on the 28th, and they're saying we're giving antibiotics, we're administering them, and are they telling her that, hey, she actually had this infection for 3 days, and we didn't treat it at all? And is there any kind of communication like that that's occurring? I mean, it seems to me, I mean, or a beloved individual in the hospital, you're there, and they say she's developed an infection, and we're treating it with antibiotics. That doesn't tell me that she had an infection for 3 days.
yes, sir. Also spelled out in the complaint is that the plaintiff communicated to the medical providers that there was a continuing deterioration in her mother's condition. She knew that her mother, was sick when she went to the hospital, and the reason that she was there at the hospital was not addressed for several days. And
But would she know that?
the complaint is not clear whether the doctor literally told her that, but going back to the standard, the question is what she should have known through reasonable investigation.
How should she have known that unless somebody communicated that to her?
Well, she should have asked the doctor, when did she start getting these antibiotics for this infection that she was admitted with? If that information wasn't provided to her in the first instance, which it may have been.
So it was her responsibility.
It is her responsibility to investigate the claim, but I think more importantly,
But only if investigation is reasonably triggered, right? I mean, only if there's enough here to sort of create that basis for why, for putting a charge that she should start investigating. And I'm still struggling to figure out what would have triggered her on the 28th to know that the hospital had done anything wrong. I mean, the hospital's there, they're treating her, people are going in and out of the room. She learns, I think on the 28th, if I've got my timeline correctly, that there's this infection and they're treating it. And I don't know how she's supposed to know that, I have that trigger that she must have had this investigation for 3 days and they must have been doing nothing about it. I mean, I don't know what would lead someone to ask that question or have a charge of being expected to ask that question.
yes, sir, and I think the important point is that not that she actually knew that something was wrong, but whether these facts should have led a reasonable person to ask, was there something wrong with that? And a delay of 3 days to get any treatment on the infection that you went to the hospital with.
Well, I think we're going in circles here because how does she know that she's not being treated?
She knew or should have known through her communications with decedent's treating physician on the 28th. And it's our position that the claim accrued on the 28th. Pre-suit notice was not sent for more than a year following that, and so was sent outside of the limitations period. Plaintiff claims that the discovery rule told the claims beyond the 29th of March 2022, but does not set forth any fact to establish discovery rule. There's no allegation in the complaint or fact in the record otherwise that the plaintiff actually didn't know about this cause of action the entire time. That's a foundational fact for application of the discovery rule that is absent from the record in this case. There's no facts regarding when she discovered it, how she discovered it, what enabled her to discover it. These are all the facts that support a discovery rule argument that are absent. The plaintiff relies entirely on the conclusory statements of her counsel, which are not in the record, that because she was a waitress, it's absurd to think that she could have discovered this. But going back to the standard, it's whether a reasonable person would have asked, do I need to ask more questions? Do I need to look into this further? And the plaintiff here had that on the 28th, and so the claims accrued on that date. I'll speak to the HIPAA authorization briefly. Judge McGee and Judge Usman have asked pointed questions that I think go to the heart of this matter, and it's elucidated in the case law that not only did defendants not have a duty to check these boxes, defendants had no right to check these boxes. The HIPAA form signed by the plaintiff is the exact authorization that she conferred, and the defendants have no right to alter that form in a way that expands the grant of authority in that HIPAA authorization. And that's spelled out in the case law, including Reese versus Waters of Clinton.
Counsel, I'd assume that you're essentially of the view that there's not a basis for distinguishing why the boxes in Part 1 would be different than the boxes in Part 2, and that they serve some purpose to be marked, given that there is a marking in Part 2, that there's no basis here for distinguishing Part 1 from Part 2.
Absolutely, Your Honor. And until today, it was undisputed that those were blank marks to be checked, and plaintiff's position was just that defendants should have checked them. And HIPAA authorization's core elements requires a designation of those who can provide records and those that can receive records, and the unchecked boxes render it such that there is no designation as to who could receive or who could disclose records. Thank you, Your Honors.
Thank you.
Good afternoon. I am Jill Steinberg with Baker Donaldson, and I represent two distinct entities that have been sued in this case: Methodist Le Bonheur Healthcare and Methodist Healthcare Memphis Hospitals. First, we want to join in the positions that Mr. Podesta argued related to the statute of limitations and the lack of an appropriate HIPAA authorization provided with the notice. But we have a separate argument that applies to Methodist Healthcare Memphis Hospitals, who was not included at all on the HIPAA authorization, not as a party that could disclose records or a party that could receive records. There were actually 13 notice parties, and the plaintiff left off 2 of them. There was also a nurse practitioner who was left off, Courtney Good, G-O-O-D-E, nurse practitioner, who was left off. So even if Your Honors determined that these boxes that plaintiff failed to check would make that authorization appropriate and HIPAA compliant, Methodist Healthcare Memphis Hospitals did not receive appropriate notice at all because there was no HIPAA authorization provided to it.
Counsel, is there an allegation, or is a statement in the complaint that associating, was it Methodist Le Bonheur Healthcare, Methodist South Hospital in relationship in terms of a DBA
So the way that plaintiff made the allegation in the complaint is they said in paragraph 3, defendant Methodist Healthcare Memphis Hospitals, and they say DBA, AKA, is a nonprofit corporation with its principal office address at 1265 Union Avenue. Then they make an allegation that defendant Methodist Le Bonheur Healthcare, AKA DBA, they make the same allegation, with its principal office address at 1211 Union, a different address, a different corporation. So whether or not they actually are DBA or AKA, we have to take the complaint as it is filed, and it sues 2 different entities. And they are 2 separate entities. The issue that plaintiff argued in the trial court and attempted to argue today that, oh, it's just the same entity, was some filings that they made that were outside the pleadings. It's unclear whether the judge considered those or not, but even if they did, if you looked at those documents, they have separate articles of incorporation and they're separate entities. So plaintiff can't sue 2 different entities and then turn around and say, oh, they're the same entity. And so we submit to the court that the statute is clear that the plaintiff must provide a HIPAA-compliant authorization permitting the provider receiving the notice to obtain complete medical records from each other provider being sent notice. Since 2 providers were left off of the HIPAA authorization form, then the authorization is invalid because there were 13 entities that were given notice. But secondly, even if,
Quick question for
Yes.
you. Methodist Le Bonheur Healthcare, Methodist South Hospital, is that the entity that is designated as the contact for records on the website?
so they use a trade name of Methodist Le Bonheur Healthcare. And the website talks about how to get, if you look at like signs and stuff, it's Methodist Le Bonheur Healthcare. But Methodist Healthcare Memphis Hospitals is the only entity that actually provides care to patients. And so when we filed our motion to dismiss, we noted in the response, in our motion to dismiss, that Methodist Le Bonheur Healthcare is not actually a correct entity because it does not provide care to patients. How you go and get medical records is a different issue and not subject to consideration for this motion to dismiss, because it's stuff outside and this wasn't a motion for summary judgment. But Methodist Healthcare Memphis Hospitals, the entity that does provide care, was unable to get records because it didn't have an authorization. And in particular, we noted that they couldn't get records from Graceland, which in the complaint, the plaintiff alleges that Ms. Murphy became short of breath and unconscious at Graceland. So if you want to evaluate the case, as the statute indicates that we are entitled to do early on in the whole purpose of the notice statute, we did not have that ability to do so.
Let me ask you one other question. And Graceland, where do they fall into this ownership umbrella? Graceland, are they?
They're a nursing home, a completely separate entity.
So you're not saying that they are part of the Methodist umbrella
Oh,
or
no,
anything?
they had
Okay.
nothing to do with
All right.
Methodist. It was just that if you are evaluating a claim, as you're allowed to do when you get proper notice, you get an authorization that gives you the names of all the parties that are being noticed. In this case, there were 15 of them.
I
But-
understand the point
yeah,
you're making.
yeah.
I just
So
thought that
they
you
are
were saying
unrelated.
they were in some way related to one of the Methodist entities.
No, they are
Okay.
completely unrelated entities, so we would have no
Thank you.
ability to get those records. So we submit to the court that under Martin versus Rolling Hills and other cases that you're familiar with, that deprivation of a statutory benefit and its resulting prejudice arises, whereas here, plaintiff's defective HIPAA authorization, and in this case, completely missing HIPAA authorization for Methodist Healthcare Memphis Hospitals, prevents a medical provider from obtaining the decedent's medical records from all other providers named as defendants. And thus, the motion to dismiss should be upheld by this court.
Thank you.
Thank you.
Mr. King, I think you've got rebuttal time.
Couple minutes, Your Honor.
Yes, sir.
I want to first of all address the issue with respect to the statute of limitations. I think that the Villas case that I alluded to earlier kind of answers those questions. It's because some of the questions that Your Honors were asking counsel were directly on point with regard to that particular case, where they were talking about more saliently in that opinion, the court was talking about, well, you know, even if you have these conversations with a plaintiff, is it that this person will have knowledge or understand that they have a cause of action during that time? And in that particular case, the court went on to talk about, lawyers, judges, a whole litany of people who may read records, may not understand or understand what's going on with regard to medical treatment, and therefore you cannot expect someone to know what's going on at or around the time that you are relaying this information to them. So the Villas case, Your Honor, I think clearly stands for the proposition that on March the 29th, this case the pre-suit notice was properly sent to the defendant. Again, with respect to the authorization, Le Bonheur Healthcare was listed there. The DBA was listed there. They could have received those records from Graceland, but they chose not to do it. And they are asserting to the court that they were prejudiced. They were not. They could have received those records. The only way to receive records from Methodist Hospital is through Le Bonheur Healthcare. Now, I understand that as Ms. Stein just argued that they don't treat patients, but they are responsible for providing records, and that's what they do. I don't have a record in front of me, but in fact, it's my understanding that when you receive a records, they have the Methodist Labana Healthcare on top of the records, even ones that you receive from Methodist, ones you order from Methodist South. Lastly, and again, Your Honor, I submit to the court that there is no prejudice here, that the HIPAA authorization had all the core requirements in it. There was an area that clearly set forth that the defendants could order the records, could receive the records, and they could disclose those records. That's clearly there, so I submit to the court that the lower court was wrong, Your Honor, and I would respectfully ask the court to reverse the lower court and send this matter back to the lower court for discovery. Thank you.
Thank you. Thank you, counsel. We certainly appreciate your argument. We will review the record, take this matter under advisement, and will attempt to enter an opinion at the earliest possible time. That concludes the call of the docket for today. We'll stand in recess to the call.